As of 11:30 last night, I received information that the ICC prosecutor Bersuda has concluded her preliminary examination against President Rodrigo Roa Duterte for the alleged crime of crimes against humanity. She will now seek judicial authorization from the pretrial chamber of the ICC to formally conduct investigation against President Rodrigo Roa Duterte. I believe that the decision to move forward into a formal investigation stage is legally erroneous, politically motivated. It is legally erroneous because in the first place, the ICC has no jurisdiction over the subject matter of crimes against humanity as alleged in her information against President Rodrigo Roa Duterte. Secondly, the case, even for purposes of formal investigation, is barred by the principle of complementarity. And thirdly, the investigation is not pursuant or in aid of substantial justice. My first submission is that the ICC prosecutor has no jurisdiction. She alleged in the first instance that the Philippine war on drugs is an instance of a crime against humanity. What is a crime against humanity? A crime against humanity is defined under the statute of the ICC law as a widespread or systematic attack against civilians knowing that the subject of attack are civilians. I will ask the Philippine National Police, when you discharge your obligations under the so-called drug war, did you target civilians? Did you kill civilians willingly because they were civilians? Obviously, the answer is no. Were there deaths as an incident to a lawful operation in connection with the war against drug, you did not target civilians as such. It was coincidental or collateral damage, either because the policeman had the right to defend himself using reasonable force, or they were in fact the subject of an attack and therefore justified by the principle of necessity and proportionality. Pasensya na po kayo. I know these are very technical language, but I speak now as a lawyer and as a member, the only Filipino member in the list of counsel of the International Criminal Court. So kapag ang laban po sa droga ay dahil ito po ay katungkulan na pulis para ipatupad ang anti-drug laws, wala pong intensyon na manarget at pumatay ng sibilyan dahil sila'y sibilyan. Kung meron man pong kapatayan na nangyari, dahil ito po ay gumamit po ng tamang pagdahas ang ating at tamang puwersa ang ating kapulisan. Bukod pa po rito, alam po natin, at mamaya po itatakil ko yan sa prinsipyo ng complementarity. Pangalawa, meron lang pong limited jurisdiction temporal, rationate temporal ang ICC. Dahil ang sinabi po nila na ang ating war against drug is a crime against humanity, yung rationale matériel, yung rationale temporaire is limited to June 30, 2016 until 17 March of 2019 when we withdrew from the ICC. Everything that happened before the President took office and implemented the war against drug, and everything that happened after 17 March of 2019 is clearly beyond the rationale temporaire jurisdiction of the ICC. Pero mas importanteng objection po sa gagawing investigasyon ng ICC prosecutor ay dun sa prinsipyo ng complementarity, at tayo naman po bilang isang naging partido sa ICC, hindi po tayo sana sumapi sa ICC kung hindi dahil sa prinsipyong ito. Ang sinasabi po na yung prinsipyo ng complementarity, the ICC will not exercise jurisdiction unless the member state is unable or unwilling to prosecute. Kapag sinabi pong unable, ibig sabihin walang estado, walang hukuman, walang pulis na gumagana. It is a failed state. Ang unwilling po is when you have legislation according impunity to an individual. Wala po tayong ganyan sa Pilipinas dahil in the first place, lahat po ng presidente matapos ang kanilang termino, hindi po lahat. Dalawang presidente matapos ang kanilang termino, nakulong. Ito po si Presidente Estrada at Presidente Gloria Macapagal Arroyo. At ang pinaka-importanting punto na dapat maintindihan ng lahat ay dahil gumagana po ang mga institusyon natin dito sa Pilipinas. Meron po tayong independyente, impartial at kompetenteng mga hukuman.